welcome to Bharata First. You're watching the Discourse with me, Rausan Pereira. Since you're here, I have a humble request. Please like, subscribe, hit the bell icon, and share the content so that more people get to know about Bharata First. That's it, nothing more. Do contribute to keep our content alive as well. The link is in the description below. A small contribution that you make goes a long way in us bringing you this content. All right then, on with the discussion. Rajya Sabha Chairman Jagdeep Dhankhar referred the three proposed laws that will replace the IPC, CrPC, and the Evidence Act to the Standing Committee on Home Affairs for examination and asked it to submit its report within 3 months. The bills, the Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and the Bharatiya Sakshya Bill were introduced in the Lok Sabha by Home Minister Amit Shah on August 11th. The bills, once passed, will replace the Indian Penal Code, Code of Criminal Procedure, and the Indian Evidence Act, respectively. In this edition of the Discourse, we will analyze the need to replace the IPC, CrPC, and the Evidence Act. Joining me on the program today are Kapil Sankla, advocate of the Supreme Court, Bimbadhar Pradhan, retired IAS officer and former Secretary, Government of India. Also with us is Mr. Yashovardhan Azad, retired IPS officer, chairman and co-founder, Deep Strat. Thank you to my guests for joining me on this edition of the Discourse. Mr. Azad, let me start the program with you first. Let's first try and understand, where we stand as far as the IPC and CrPC are concerned. All laws that have been put in place several decades ago, in fact, in a different century altogether. And finally, we are moving ahead with trying to replace them with something new, something more relevant in today's day and age and today's times. How would you look back at this entire issue?
Well, that's the aim which you said of these laws, or purportedly the aim has been that these laws, which were constituted in the 19th century for a different kind of things, by a different kind of a set of rulers, do they correspond with the people's aspirations in today's times? And that's a very, very critical question, which I think each country is asking after independence, especially countries like India. Now, the issue is per se, our criminal justice system is something much, much less to be desired. There are too many faults, there are too many fissures, and there are too many gaps. So at the outset, I would say a good step. There are other countries, and I'm sure, Kapil would be straight away telling me there was a different way of doing it. And I agree with him. For example, you should not change the major section 3002 should be, it should stick with murder. And so that, there is too much of overhaul is also very, very difficult to kind of digest. But what I would say is that it's a good step. It's a big country. It's the largest democracy. So the signal given is, yes, we want our criminal justice system, which corresponds to the reality today. And it also takes care of human rights and all that. The question is, has it done it? Well, the first thing I would say is, I'm very happy about introducing mob lynching as a particular section. This is something which was worrying us. This is something which is abominable in a country like ours, which is, a democratic country. I would also say to that extent that even the dropping of sedition, because, at least I have been speaking on all platforms that this is one thing which should be totally dropped. It has no place. Well, you can certainly say that sedition has been taken through a back gate. And then, the point is, and this is my second point, that no matter whatever good beginning you have, because no point listing all that, all of us know. The question is the arms of execution. The question of implementation of these laws, you have to correct the instruments of harm. So do we say that the police today is in a position to execute all these and implement the laws faithfully? Can we say that police will not misuse the law? So what should we have done? The cart before the horse, like you say. I would have certainly, expected that, after doing so much of exercise, couldn't you sort of make a model police act? Every state has violated the Model Police Act. So it is quite apparent, and Pradhan will agree with me, that, everywhere the instruments of the civil service are firmly under the control of the political executive. So given that, yes, there'll be a problem with that. My second point again, the prosecution. The prosecution actually is in tatters. Whereas on the other side, on the defense side, you have fantastic lawyers like Kapil. On our side, from the prosecution, you have guys who have 100 cases a day who just don't know what is one different from the other. And perhaps they're not motivated, not interested, and there's no layout for them to pursue those cases. And then after the prosecution, then you come to the judiciary. Now, this new law will be tested against a higher conviction rate, will be tested against better conviction, or it will be also tested against speedy disposal. So what are we doing about speedy disposal? 7,000 crores have been, that the Chief Justice says has been spent on the court system. Are we going to have a fast track system? Are we going to have, a continuous hearing? And the last, the prisons. Prisons is the pits. So when you're talking about the criminal justice system, you just can't leave it alone hanging. This itself, at least I'm happy, it has gone to the Parliament Select Committee and it will be for wider consultation. Lots and lots and lots to be done. And finally, in the end, I'm a little surprised that, when you have these kind of laws, the instrument, the arm which is going to exercise these laws, which is going to uphold the human right, are the cops. So whether you like them or not, somebody should have been a member of this committee to say, ki, haan bhai, hamare yahan, when we catch, we have this 102 CrPC, Kapil will know, we keep on collecting junk in the unclaimed property, and we don't have any right to dispose it of. What kind of thing is this? So we go to the court, take a date, court doesn't have a time. So there are many, many things which we can do. Therefore, I hope the Parliament Select Committee has a police officer, has a lawyer, has a prosecutor, and has the other arms, so that at least we can, make the proper suggestions and they may be put in the final draft.
Absolutely. All the boxes need to be checked, and maybe the dots can be connected. That's left for another time. We hope that the dots are connected at some point in time, and that's the hope that we all have. Before we bring in the legal expert and the legal points, Mr. Sankla is making notes very patiently, true to his form, and I know he has a lot to say about this. But before I bring you in, let me bring in Mr. Pradhan as well and talk about a particular aspect that Mr. Azad just raised about this matter needing deeper discussion, deeper consensus as well at some level. And that's what's important. And I'm glad. And I think as a country, we are all glad that this has gone to a parliamentary committee where deliberations will be held. And we hope that the best put is put forward. So is this a positive step, Mr. Pradhan, that we're going to see at least consultations on this particular issue?
I think, sir, given the, I will just stretch it a little bit where Yashwardhan Shah has left it. If you take the backlog of 50 million cases stuck in Indian courts, two-thirds are the criminal cases, and mostly in lower courts. And 77% of the prisoners are the under trials. This we must keep in mind. 50 million cases are pending, and 77% of the prisoners are the under trials. Therefore, what Yashwardhan Sir has mentioned, it is enforcement, it is implementation, and if I have to take it, a little bit, the due process and the personal liberty, these are the inviolable human rights. Threat to them flow both from the law books and also from the structural and the institutional reality. Therefore, the new bills, what I have to again emphasize, these very bills have been referred to the Parliamentary Standing Committee. They need deep study, deep analysis, and at the end of the day, it is the citizen, whether it is Aam Aadmi or Aam Aurat. The citizen must be the fulcrum, and citizen must be the core of whatever reforms is required. It is ease of living and speedy trial, speedy justice, timely delivery of justice, and if possible, whatever is the requirements of a modern progressive society, of a modern nation, and which is, dreaming to be third largest economy. Therefore, if we are, evolving with the changing times, with the advent of new technology, our laws must be in sync, keeping the citizen at the core of the entire reformation of the criminal justice system.
Absolutely, very well said. I think that should be the moot point, and that should be on top of the agenda as far as these bills are concerned. The citizen has to be right on top, and everything else should come next. Kapil Sankla, let me bring you to the picture now. Several legal aspects to be looked into as far as the IPC and CrPC are concerned. From a legal perspective, how would you look at it?
Well, one, I would like to tell Mr. Azad that I'm all for the amendments that have been made.
Your sheet of paper where you're making notes is coming in the way. If you could just
I'm so sorry.
please. That's okay. Yeah.
Yes. I was wondering what went wrong. Yeah. So what I was saying was that, just to add on to what Mr. Azad was saying, I think it was high time that the laws amend. We have to appreciate that CrPC has gone through 23 amendments till date. It was brought forth in 1973. IPC has had 77 amendments till date and more. But what's important is that this bill which is there, which proposes to be the law, actually takes care of every judgment that the Honorable Supreme Court has given as far as laying down the law and the procedural aspect of law. So what basically happens is, as far as the criminal jurisprudence or the legal jurisprudence is concerned, where there is a legal vacuum as far as the legislature is concerned, the Honorable Supreme Court may lay down the law to fill that vacuum. But you still have to wait for the legislature. So when you talk about Vishakha guidelines, etc., these were all laws that were created by the Supreme Court, and then they were eventually converted into laws. All right. Here, what has happened is that over the years, forget the amendments for a minute, the knee-jerk reactions that we've suffered, for example, the Delhi rape cases, then you had amendments as far as the women laws are concerned, 354, 376, all the amendments. When you talk about the aspect that, the law actually mandated now that there has to be a woman police officer recording such statements. When there was an issue when the Bose judgment which said every police thana would have a CCTV camera or the right to be informed, etc. All of those issues that were laid down by the Honorable Supreme Court have been duly considered here. And they've been considered here because it is not as if the legislature, the politicians sat down behind closed doors. We all had a part to play. I personally have been a part of the committee that recommended changes, etc. So did the NLU Delhi, so did the other NLUs, etc. So the issue here is that as far as these amendments are concerned, these are actually taking care of the good laws that were created to protect the public at large. As Mr. Prasad said, the idea is to protect the public at large. And laws stagnate just like society if there is no change. Changes were coming. It is a good time rather than having various amendments over the years which kind of confuse the law and convolute the law. And also make the law open to interpretation. So now just for a second, look at what the laws say. They say that videography is allowed. They say that recording of evidence is allowed. They say that, if an accused or a witness cannot come, that in absentia, the trial will go on for an accused. And as far as the witness is concerned, he can do cross-examination, and all of that can also take care through the internet. Now, all of that we've seen is already being done in the sense that this was permitted during the lockdown. So why not create a law now that actually takes whatever is best and what we've seen has worked? And this is exactly what has happened. Now, every aspect of the change which is there is open to interpretation, of course. And I'm in complete agreement with Mr. Azad that much more could have been done. Absolutely. There are various protective mechanisms that we've been talking about. For example, the prosecution and the investigation do not work in tandem. After 25 years, I'm actually the special public prosecutor, and I've been a defense lawyer all my life. And I'm shocked to see that the prosecution who goes to the court does not have the advantage of talking to the investigator before the matter comes before him, and vice versa. So what you have is bad evidence or secondary evidence or evidence that gets tainted because the investigating officer did not know what to do or wasn't trained properly. or did not consider the latest law as has been held by that High Court or the Supreme Court. So all of that has now been taken into consideration. And I would love to meet and explain what the different changes are, but I'll leave it to others right now.
Absolutely. Mr. Azad, let's get into specifics now and talk about one particular aspect. We're talking about evidence gathering. The new bills focus heavily on forensic sciences and that aspect. Now, are we prepared to really gather that kind of forensic data or forensic evidence? Is another big question. The infrastructure has to be overhauled. We need better training of the police force per se, because say for instance in the metropolitan cities maybe it's going to be possible, but same is not going to be the case in the hinterland of the country. So what do you do there?
You've stolen my point. In fact, I've written an article on a daily newspaper where I've mentioned this part extensively. The issue is that the states are on a very, very measly budget. Not as far as things are concerned to give away for freebies, etc. But as far as the police goes, the investigation goes, there's just no money for it. And now I'm extremely happy that forensics has been included as one of the major items. It has been given a major push. And therefore, for important cases, forensics are a must, because as you know, Kapil said just now, our biggest problem is marshalling the evidence in a correct manner. See, one thing which I'm so happy which he has mentioned is all over the world, we have a prosecution-guided evidence, prosecution-guided investigation. Now, there has to be a connectivity, and that's exactly the point which I have been making. The prosecution is in tatters because it does things on its own. The investigation does not have any advantage of what is the use. During my times, at least, there was an APP over there, and when I used to look at a particular case, then I would call both of them and say, here you're accusing him of this, where is the evidence? So, marshalling evidence accordingly is a very, very important thing which needs to be done. I'm very happy Kapil has said this. Now, in the case of forensics, you have 730 districts or 6, whatever districts you have. Each district has which is covered by almost has a population of around 10 lakhs. That is the average here we are talking about. And then is distribution. I have been in rural areas, and Pradhan has also been, where you have A-class gaon and B-class gaon and C-class gaons, and where they have to be linked to the subdivisions. So how many of these forensic laboratories are you going to set up? It will be at the headquarters, and what about the mobile forensic labs? What about the people who are going to be with it? What about the air conditioning facilities? What about even you're talking about the CCTV, etc., with the support of electricity, the Wi-Fi system, the bandwidth? All these are going to be a massive, massive issue. So when we are talking about the digital highway, when we are talking about Wi-Fi reaching across every panchayat, this will need a lot of effort. So there are ways of handling it. I mean, I don't know whether you'll be concentrating on one side, but the biggest problem is of federalism. Will the center be able to impress upon the states that, listen, hey, we have got these new laws so that the whole country moves forward together? Can we have a proportion of substantial expenditure from your side so that there is an even development? Otherwise, you'll have some states in the south moving far ahead with all these forensic labs and CCTN and things like that. And whereas the states like Bihar and UP, the poor states, will not be contributing anything. So there'll be a huge mismatch on this point, which I'm extremely worried about.
Absolutely. And Mr. Pradhan, let me bring you into the picture once again. Now, as far as certain challenges and certain difficulties are concerned, if you could highlight some immediate challenge that you see apart from what we have already spoken about.
I am not going into the three Sanhitas. If you take it, the Nyaya Sanhita and the Nagarik Suraksha and this very Sakshya Bill 2023. But what Yaswardhan sir was mentioning, if you take the entire geographical terrain of India, see the Daltonganj in Palamu is different from say Malkangiri of Koraput district.
Absolutely.
The very, a police station in Bastar and a police station, let us say, in the eastern part of Orissa. The police station in Patna is different from a police station in Araria, Kishanganj, which is, bordering our, say, Nepal, the Tarai region. Therefore, given the geographical, the vastness of this country, at the end of the day, when you talk about any reform, I will put it into three, F's: the funding, the functions, and the functionaries. Given the, the geographical diversity, given the, the federal nature of Indian democracy, therefore, the criminal justice system or the reforms must be backed by the necessary technology, the necessary resources, the necessary funding, the necessary functionaries. Therefore, if you take the last part, that is, say, Sakshya Bill, the Evidence Act, definitely it is a, step in the right direction. The electronic evidence, now we are talking about the artificial intelligence. Therefore, when you talk about the artificial intelligence, we must be aware of the positive aspects of the artificial intelligence and also the adverse effects of the artificial intelligence. Therefore, if I take a little bit, from the speech of the Honorable Home Minister in the Parliament, our police personnel or our police functionary, whether it is at Bastar or the Daltonganj or Malkangiri, they must be well conversant with the provisions of the, these new bills, and they must be prepared and they must be in readiness to take it at the grassroots level for ease of living of the common citizen, whether it is Aam Aadmi, whether it is, a woman or a child. It must be for the benefit of the citizen, but they must have adequate resources, whether it is digitization, whether it is technology, whether it is CCTV, whether it is video conferencing. All these things are open courts, or the, whatever required. We are talking about the police modernization maybe for the last 20, 25 years. But look, what is the ground reality in a police station in Malkangiri or Daltonganj, or even a district like Araria or Supal? You have to visit to those police stations to see the ground reality. Therefore, the reforms in the criminal justice system must be supported and backed by the 3F: funding, functionaries, and adequate awareness at the grassroots level. Thank you.
Absolutely. Very well said there, Mr. Pradhan. Kapil Sankla, let me bring you into the picture once again. I'm going to go back to a point that Mr. Azad made in his opening remark about mob lynching and, the fact that all these elements have come into the new bills and we hope to see them to some fruition. But then it brings about certain challenges as well, because when you're looking at a mob of, say, 100 people, now, are you going to convict all 100 of them of murder for killing one person? And what's going to happen there? So there's a lot of it is going to be in the details, isn't it? And several of these details will actually have to be thrashed out. And the officer on the ground, the police personnel on the ground, needs to be aware of all these aspects and new changes as well if we have to move forward smoothly.
Well, to me, the second point first, I think what is truly required, as Mr. Azad rightly said, is that the police personnel on the ground need to be trained. They also need to be sensitized. And they also need to be trained to be empathetic. That being said, you also have to understand that, to take your example, if 100 people, a mob, do you punish them for murder? That law already exists. So you're talking about conspiracy where there's meeting of mind, and there's abetment where everybody is presumed to have done the same act because you cannot distinguish what the mob has done. So what I was trying to say is that most of what we see today in this bill is a part of the judicial precedent that has stood the test of time by the Honorable Supreme Court over the years. So when you're talking about bodily harm, right to life, right to your personal body for a woman, all of that are part of judicial precedents. When you're talking about recording, that's something that we saw during the lockdown. When you're talking about digitalization, that is something that we saw during the lockdown. I mean, would you believe it, today in Honorable Supreme Court, no paper is filed. It's all digitalized. Honorable High Court is doing the same. The trial court can also do the same. The responsibility and the onus is on the lawyers. And we are all happier with the changes that have taken place. I mean, just before lockdown, if service had to be affected, we would be, sending registered AD, UPC courier. Now we send a WhatsApp. So the changes have already been made. The only thing is that most of the people on the ground were not aware. And this information, for reasons best known, was kept with us. Now, when you talk about, as you said, the changes which have come into place, I just want to tell you this. Zero FIR, it's a beautiful concept. Wherever the accused or the victim is, or wherever the person is residing, can inform the police is duty bound to register the FIR. On ground, it does not happen. So the Honorable Supreme Court says in Lalita Kumari judgment that if it does not happen, it would be a contempt. But this bill that talks about zero FIR, the concept comes from Lalita Kumari, which comes from Justice Verma Committee, which comes from the Nirbhaya Kant case. When you're talking about, for example, safeguard from arrest, 41A, the concept that was introduced came from Arnesh Kumar in a judgment which was of Uttar Pradesh. When you talk about recording of evidence, it comes from another judgment. It emanated out of Bose judgment, as I said. So all of what we see today can be done and has been done. It was just not a part of, so to say, the act itself. These were all disconnected, disjointed facts which lawyers knew, which many police officers knew, not all of them. So the whole idea is to consolidate and put it in one box. And you're making the police responsible here. And I do understand that, the Buxar is different from Mumbai and Delhi is different from, whatever, Dehradun or whatever, Bihar versus Bombay and all of that. But the fact is this, that the law is common for all, and it is a great equalizer. When you're talking about, for example, RTI Act, there was a lot of disconnect about RTI Act, etc. Different states had a lot of problem. Different departments had a lot of problem. But the fact is, it is a great equalizer. Today, you're making police, the prosecution, the counsels, the accused also responsible. Now, I cannot go about taking whatever dates I want to take because I think I have a weak case or because the judge is not with me. I can't take more than 2 dates, whatever the case may be. The evidence will all be videographed. I cannot go to a superior court and say, listen, I said this, but it wasn't recorded because it's now videographed. Now there is also onus on the court itself, which was never there. The court has to pass an order within a stipulated time, finish trial within a stipulated time, and all of that. That also came from some orders of the Honorable Supreme Court that said that the judges cannot sit on orders for 6 months, judgments for 6 months. So as I was saying, all we require today is acceptance and will. Because we've been doing this now for a number of years any which ways. We've accepted it. The only thing it is now time to consolidate it so that education can be disseminated. That's all I wanted to say.
Absolutely. So it has to be formalized. It has always been in existence. It needs to be put on paper and then taken forward is what Kapil Sankla is suggesting. Time to get quick closing comments now from all the panelists with the best way forward and what next. Starting first with you, Mr. Raza.
I'm of the opinion that it's a very encouraging move. And I think we should go forward. The Parliament Select Committee should bring in, all shades of opinion, all sections of people, because ultimately this law is going to be for the people. And that's why I'm very, very hopeful that we are on the right trajectory to, in fact, revamp the criminal justice system of this country.
Absolutely. Mr. Pradhan.
Yeah, sir, I think I will just tell only 3 lines. A, the timely justice delivery must be the ultimate goal. It is justice delivery that must be the fulcrum. 2, the standing committee must undertake a deep study, must have due deliberations, must consult all the stakeholders. They should not rush through. It must be rigorously and vigorously debated and deliberated before the bills become an act. 3, we must have adequate steps to minimize the vagueness or the ambiguity, whether it is the concept of terrorism or the Deshdroh or Rajdroh. Okay, we have, deleted sedition, but we have brought, the treason, the activity which is going to, have implications for the unity and the integrity of India. Therefore, we must be careful in defining all these new aspects, whether it is cybercrime, whether it is mob lynching, whether it is, see, the sexual intercourse with a woman, promising promotion, promising a job, promising false marriage. The finer aspects needs detailed discussion and deliberation. Last, steps be taken so that whatever changes in a modern nation in the 21st century for a modern society, to address the new technology, to address the issues of artificial intelligence with digitization. Ultimately, it is the simplification of the process and it is the timely delivery of justice. That should be the ultimate goal. Thank you.
Absolutely. And Kapil Sankla, close the show for us with your concluding remarks.
Two quick asks that I hope would be taken care of. One is the laws should all be gender neutral. You see, Justice Chandrachud has said that sex is not, the orientation is not according to your DNA or your birth, but it is an orientation as far as from your thoughts or your belief. So gender neutral laws, first and foremost. Secondly, the whole idea of these new acts coming into place is to remove the discretion that anybody has, be it the police, be it us, investigating officer, and also the court. When you're removing discretion, I really hope that they also amend the Bail Act, so to say, or the laws pertaining to the bail, so that they're standardized. It is not to the whim and fancy or the mood of any party concerned, or it is not to the absolute discretion of the court as well. So you have a Bail Act which you give marks, for example, I don't know, first-time offender, minor offender, deep roots in the society, taxpayer, etc. And you give those marks and then you give some discretion for lawyers like me to go and convince the court. But there has to be some kind of standardization as far as the bail is concerned. That's second. And third is something which is my belief as far as the new act is concerned. You see, as I said, that laws like society have to change or they will stagnate. Your morality has changed over the years. Your customs have changed over the years. It is high time the laws also change and take into care what is truly happening right now.
Very well said. All right. On that note, then we'll have to call it a wrap on this edition of The Discourse. Thank you to all my guests for joining me on the program and putting things into perspective for us. So what's coming out of this discussion is that the new bills are a step in the right direction and the need of the hour. It is a good thing that the bills have been referred to a parliamentary standing committee since they need thorough deliberation. The working out of the finer details is what's going to be key and needs inputs from all stakeholders. Facilitation of that is going to be crucial. The provisions in the bills have come out of landmark judgments which have stood the test of time, which enables hassle-free change. The most important aspect, however, is to remember that the citizen must be the fulcrum and everything should be around it. That's it in this edition of The Discourse. But since you made it still here, I would remind you to like the video, subscribe, hit the bell icon, and share the content so that more people get to know about Bharata first. We also have a YouTube membership program with some great perks. Do check them out under the join button and join now. Until next time, this is Frank Rausan Pereira signing off.